Okay. All right, you've been promoted to panelist, so.
Whether you wanted to or not.
People watching us right now. I don't know, it's 6:06. I don't know if you want to go ahead and get started or.
Yep, I think we're probably good to do so. Do you want me to start and then we can go from there? Okay. For those of you who I've not met, I'm Annette Kimball. I'm the Executive Director at Forest Creek Memory Care. And we decided to work along with Casey Elder Law to just give you all some updates. I know our support group, which prior to COVID, we met once a month at the end of the month. We had a lot of questions about elder law, and you all were on our list to have come speak to us in person, but unfortunately not able to do that. And you all were very kind to offer to do a Zoom. So that's kind of where we got started from there. And then I'm going to let Angie introduce herself. She is our new marketer at Forest Creek. I actually stepped out of that role into the ED role about a month ago. And so she just filled my position 2 days ago. So this is just her second day with us.
So I'm looking forward to meeting all of our families. As Annette said, my name is Angie Connley. I've been working in senior living the past 4 years and as a sales manager. So this is just a really easy transition for me to make. I'm so excited to be here. So that's kind of my story.
And then I'll let you all introduce yourselves, give us some little history.
Sure. I'm Amber Thaling, and I'm one of the attorneys here. Been here about 19 years, going on 20, I guess, something like that. And yeah, so that's me. And actually, Rachel and I were in law school many moons ago together.
Yeah. So my name's Rachel Spathy, and I've been here with Casey Elder Law about 4.5 years or so. I've practiced law for 20. And I met Amber. Actually, we both have our law degrees, and we both also have masters in social work as well. We did the joint degree program at KU. And so prior to coming to Casey Elder Law, I worked in foster care and adoption family law, and did a lot of adoptions and guardianship cases through that court. So it's been a nice change to come to Casey Elder Law. I really like it here. Very, very good group of people. So,
what brought the two of you to be interested in elder law?
Mine was a happy accident. I was doing family. Actually, Rachel and I interned at the same family law firm. Love the people, but I did legal aid in law school. So I got a phone call from the director. His name's Chuck, and he said, "Hey, I've got a job lead for you." And I'm like, sure. And he's like, elder law. And I'm like, ugh. I'm like, no. He's like, no, you need to call this girl, Jill, at the time, who was here then. And I kind of sat on it. And then Chuck and I were supposed to have lunch one day. I was like, oh man, I really have got to call Jill. So I called her, and I was actually on my way to my sister's house for lunch at work. I still remember sitting in front of her house. And within 5 minutes, I knew I wanted the job. So, and the rest, as they say, is history.
Great.
yeah, I was gonna say, and for me, it's a really good fit. I feel like with a background in social work, I really like working with families, and elder law is more than just, drafting documents, because it's working with families, seeing what fits the situation the best, understanding dynamics. So it just really lends itself to a lot of, normally pre-COVID, a lot of client interaction. I love going and meeting with clients at, wherever they are in their home, whether it's a care facility, and really being with them in their space, and making sure that they understand, all the documents that we do have. It's just a good fit, I think, for people like Amber and I who enjoy the social work part as well. So
absolutely.
Very good fit. Yes.
And half of our job is social work most of the
time. Yes, I can see that. I know my mom recently passed, and my dad has been navigating the whole system. They had an estate set up, and there's been lots of questions. So I'm looking forward to hearing what you have to say about the estate planning and the power of attorney information. So I'll let you all take on over on that regard.
Okay, Rachel, you're up.
I got my notes. So I'll just kind of speak briefly about I was asked to talk about the powers of attorney, and then if there's questions, of course, let us know. For us, when we initially meet with people, we want to look and make sure that there are good foundation documents in place. And because we are an elder care firm, we look at it from a planning, long-term planning standpoint. So we want to make sure that the documents we have allow for family members or friends to help long-term for planning, for in case there would ever be a need for a nursing home care, or if there would ever be incapacity. So we really look to make sure that the documents are well drafted and are in place to take care of people in later stages of life. And we have two different kinds or two different types of powers of attorney. Often you'll hear people talk about a healthcare power of attorney, and then there's also a financial power of attorney. And those are actually two different documents, and you are able to name people who, so while you have capacity, and I know Amber will talk a little bit about that piece next, but while you have capacity, it's really good. You're able to say who you want to have help when you don't have capacity. So it's a very good, they're very good documents to have in place, because if you don't have those and you lose capacity and you can't manage your affairs and you can't name somebody to manage your affairs, the other option is to turn to the court and ask for somebody to be appointed to make those decisions. And that gets to be very expensive and time consuming, and it requires court oversight. Whereas the powers of attorney allow for you to say, if I need help, these are the people who I trust, and I want them to be able to manage my affairs. And so for the financial, it doesn't take any power away from you. So if you sign a financial power of attorney, it's just naming people who can act on your behalf. And you have several ways you can do that. You can name people to act jointly and severally, which means if you name both your brother and your sister to act on your behalf, and you name them jointly and severally, it means that either one of them can act for you. So whoever's there can act on your behalf, or you can name one person, and if they're not available, name another person. So you can do it in succession, or you can do a combination. You have a lot of different choices of how to structure your agents in your document. And then you also have a healthcare power of attorney. And so for our documents, we have two different sections of our healthcare power of attorney. And one is, for the general types of decisions. So if you would have surgery or something happened and you're temporarily, you can't make your own decisions, it names somebody who can step in and act for you. And then we also have a section in ours that allows you to say what you would want your end of life to be like, your quality of life. If doctors didn't think you were going to recover, you are able to say, if doctors don't think I'm going to recover, I'm not going, if I'm unconscious, persistently unconscious, and I'm not going to be able to make a comeback from whatever's going on, you're terminally ill. These are the sorts of things I do want for my care, or I don't want for my care. So it really is empowering for people to have a healthcare power of attorney, because it allows you to say what you want for your healthcare to look like when you can't make those decisions. So powers of attorney are only effective while you are alive. So if you have a financial power of attorney, like for your mom or dad, once they pass, that document's no longer, you can't act on their behalf anymore. It's only during their life. And we structured our powers of attorney in a way where the financial is effective immediately. So once you sign it, people can act on your behalf and help you. And then the healthcare, of course, is only when you can't make your own decisions. So they're very good documents to have in place, and they really do prevent court involvement down the road. I know that in this firm, I do some guardianship cases and conservatorship cases, and one of the first questions we always ask is, is there a power of attorney? Was there ever one? Can we do a power of attorney? Because that is much more, it's less restrictive than a court involvement, and you always want to make sure you're following what your loved one's wishes are, if that's possible. So to have good powers of attorney in place can really save you a lot of time and money and worry down the road for both yourself and your loved ones. So Amber, I don't know if you want to talk a little bit about the capacity, because
Sure.
issue that is a big
Yeah.
piece of this.
Yeah. There are different levels of capacity. And so as I tell clients or their kids or families, like, I don't care if they know who the president is or what day of the week, but do they know their family? This is my husband, my son, my daughter, my aunt, my, whoever it may be. And yes, I trust them to manage my finances. So even though somebody is being diagnosed with some kind of cognitive impairment, it does not necessarily mean that they don't have the capacity to sign a power of attorney. There are different levels. Could they enter into a contract to buy a car? Maybe not. But this is my family and these are who I want to manage my affairs. There also can be some fairly significant gray areas of capacity, and you do have to be really careful and cautious. I talked to one family member the other day, and they have a letter that, mom doesn't have the capacity to manage her affairs anymore. Well, this was pre-us, but mom had signed a power of attorney. That letter had been drafted before she signed it, and they're trying to sell a house, and they're saying, no, she signed it after that letter was written. So what needs to happen, what we're talking about, is a letter to the physician that says, even for the for the physician's signature, that even though they cannot manage their day-to-day affairs, they still have the capacity to appoint somebody to do so. Kind of the murky, not so good area. I see it happen when there's bad family dynamics. One kid wants one thing, one kid wants the other. So mom or dad can be kind of like the child of divorce. They're going to tell, son what he wants to hear when he's in the room, daughter what she wants to hear. And that's frequently, if there is not a power of attorney or if there is fighting, then a guardianship conservatorship is the way to go there. Because then your capacity really isn't there to be able to make that decision. If they're going to tell one person one thing and somebody else the other. It's not that they're being difficult, but just not that enough capacity. So powers of attorney, when it comes to the financial, usually you see them two different ways, two primary. There's durable, which means it's in place the second that you sign it, as Rachel said. It ceases at death. Whether you have capacity or not, it's in place. There's also one called a springing power of attorney. In our world, we really don't like those at all, because it says it's only in place at incapacity. So a doctor has, one or two doctors, depends on the document, has to declare you incompetent or incapacitated before somebody else can step in and manage your affairs. Well, in our worlds, frequently clients have capacity, they just need help. Maybe they're doing a rehab stay, or, it's COVID, they can't get out, they're fine, but they need their kids to go to the bank, to call the life insurance company to manage things. So that's why we like durable. We do not like springing. No. I did have one client where actually it was appropriate. She was widowed, had no children, and she was the most private person on the planet. And she was still in good health. She was fine. And she was listing a best friend, but she was like, I absolutely, until I'm 3 sheets to the wind, don't want her to know anything. So for her, that made sense. But that's kind of, a very small percentage. That was, I think, the only time I've ever done one of those in 19 years. So, because normally we do steer away from that. I said, well, if you're sick and in the hospital and things get complicated, you may just need to redo your document. And she was fine with that. As long as she has the capacity. Powers of attorney are revocable. So if somebody has the capacity to do so, they can change it. Once a person loses capacity, the person that they've appointed cannot make it, generally speaking, cannot change the agent. So there's language in there, it's called a power of appointment. We typically don't have that in there because we want our person to list the people, not leave it up to the discretion of somebody else to say, oh, well, I think this person should, so I'm going to list them. But so once somebody loses capacity, you're stuck. We got a call from, well, one family member, then another family member. They're not our clients, but there was some debate as to whether or not the agent was acting in the loved one's best interest, possibly draining bank accounts, things like that. Well, the loved one no longer had capacity to make a change. And so the other family member was looking at needing to apply for guardianship conservatorship, because financial abuse is elder abuse. So if somebody isn't managing it appropriately, somebody else needs to step in and say, you know, time out. This isn't working, and whoever should be appointed. Anyway, does that answer that?
Yeah, can you speak a little bit to the function, and I may not be saying this the way I'm really asking, but the function of a trust when setting up estate planning?
Yeah, I'll start. Rachel, you can jump in. A trust avoids probate.
Okay.
Is the bottom line. A lot of people think, oh, I'm going to protect my assets. I don't want the state or whoever. Trust avoid probate. And a trust is not necessarily dependent on the size of your estate. I had clients that had $1 million in a house. Well, they were leaving it to their 5 boys or the survivors of that. All boys got along.
Mm-hmm.
So we did transfer on death deed to the 5 boys of the survivor, and they did the same with the beneficiaries on all their accounts. Now, if there had been family dynamics and drama, it might have been best to set up a trust. So even though all 5 boys would have been treated equally, that one person was in charge of selling the house, paying the bills, and then dividing up the cash. But they were like, we're all good. So they didn't need one. I've had other families with small estates that sometimes you're like, you typically would say, no, you don't need a trust. I think you're fine. But then as they start talking about where they want money to land when they're gone, who should be in charge of it, then it's like, you know what, actually to make those goals happen, you do need a trust. So a trust is essentially its own entity. You can fund it, title accounts in it while you're alive. The other option is you have your accounts and they're payable on death to your trust. So one of 2 ways it lands in your trust at your death. So the power of attorney would have authority to make decisions on your finances for all of those accounts outside of the trust. If there are accounts inside of the trust, titled in the name of the trust as opposed to an individual's name, then the trustee manages those accounts. So there's 2 different jobs, essentially. So a trust says, the way ours are, estate planning trust is, this is my money while I'm alive. I do with it what I want. I can buy and sell my real estate, open and close my accounts. But when I'm gone, this is what happens. Here's who's in charge and here's who gets it.
Okay. Rachel, did you have anything to add?
Where I've seen it useful, and Amber kind of touched on this, is when you have, especially like if you have minors that you want to get money and you need somebody else to manage it, or if you want people to get a certain amount at each age, or upon maybe graduating from college, or, and you don't want to make it too complicated because you need to make sure that the trustee understands and can follow, what the wishes are. But that it is, I've had a couple unique cases where the person really wanted to control where the money went from the grave, kind of, so to say. They really wanted to be able to make sure it was managed the way they wanted and give monthly distributions, and the trust was the way to allow that authority. So
yeah, it lets you be very specific. Mm-hmm. If Susan dies and she has no children, then I want her share to go to my grandchildren as opposed to her siblings. Or, I want 10% to go to this charity, 20% to these people. Like Rachel said, you can just be a lot more specific.
And also, we see quite often where people come in and you can modify them. So you can come in and restate your trust and change your beneficiary designations. It can be a kind of more fluid document that you can change as things change. So it definitely does fit some family situations.
And also, just on that note, with an irrevocable trust, frequently, more often, 99% of the time, you can actually revoke an irrevocable trust. You've got to jump through hoops. But people say, I've got an irrevocable trust, or mom does, we can't do anything. It's like, well, let us take a look, because we've busted those up before. All of a sudden there was this irrevocable trust, money was in it, mom needs care, well, they need the money to pay for the care. Everybody was in agreement, and so Kansas and Missouri have different hoops you have to jump through. But generally speaking, they can be broken up. So irrevocable is not always irrevocable.
There's always a way out, right?
Pretty
There's always
much.
a way out. Yeah, and I think my question was very personal because my parents had trusts, and my dad did not know prior to my mom dying, she'd been sick for quite a while, that he needed to go ahead and establish an account with her trust name. And so it took, some extra hoops to jump through after her death to get that account set up so that the life insurance and things that were, beneficiary to the trust could go through it. And I think he thought he was very well prepared and, had it all planned out. It was just a step we missed in that process. So.
Well, yeah, because we get the calls if it's an individual trust and you die, your social security number, which is the tax ID number dies with you.
Yes.
So you have to apply for a new tax ID. It's called an EIN, an employer identification number.
Yeah.
And so you have to apply for the trust's new social security, right, for all of that stuff to happen.
Yeah. And it was very stressful because he really didn't understand it. He just kept saying, why did I spend all this money on a trust when it's not helping me? He just wasn't understanding that there was a step he missed. So, and
it's nothing you can do until somebody dies.
No,
are
you able to set up an account prior to them dying?
Well, a lot of our clients have accounts titled in trusts.
Okay.
But you have to do the new tax ID number.
Okay.
For the account, essentially.
Okay, so you would still have to do that no matter what.
Mm-hmm.
Okay. Well, how about we open up for questions? I don't know on this Zoom what's the easiest way to ask it. I think, are they able to just type them in?
They can type them in. If they want to list them as private, so people don't know who they are asking,
okay,
then our moderator, Jana, that you can't see, will then feed us the questions.
Okay. Okay. So
but if they want it to be public, it'll pop up somewhere, is my understanding.
Okay.
And Jana can text me if I'm wrong.
Yeah, I've not done one this way. So is there any questions from anyone? Yeah. Angie, did you have any questions?
No, but I love the trust question because that's something I've always wondered about also and not understood. So I'm so glad you asked that.
Oh, the other thing is hold on, Janice. Okay, we're good. The other thing is people will say, I have a will, I'm not going to have to deal with probate. A will by definition has to go through probate. It means probate. It's a good backup. So let's say you've got 3 kids, everything is going equally. You still should have one that allows people to wrap things up, deal with the end of, again, wrapping some stuff up. It's just like if your will though says everything goes to me, but Rachel's name is on all of your accounts, Rachel's going to get all the money. I get nothing. So it's only if something goes through probate. So sometimes even if clients have smaller estates and we're not doing a trust, we still do a will. For example, Rachel and I are siblings. Mom wants to disinherit Rachel. Mom should do a will that says, I intentionally am leaving nothing to Rachel. It all goes to Amber. Let's see. I'm getting a question, but I can't see all of it.
I can read it. Do you want me to read it to you? What do you do after death with a trust that has its ID number?
You apply for the EIN, the tax ID number. You can do it on the irs.gov. And there's 4 ways that property passes at death. There's joint ownership. You and I have a joint account. I die, it's yours. You die, it's mine. There's beneficiary designations. So that's life insurance, IRAs, other accounts, of course, but it's in my sole name and I list whoever as the beneficiary. I died, the company gets a death certificate, the person gets the check. Then there's the trust that we talked about, lets money be divided however, and then there's a will, which by definition goes through probate.
And I will tell you all, check who your beneficiaries are on life insurance policies. my mom had a really, really old life insurance policy, and her mother, who would be well over 100, was still listed as the beneficiary, and that was another hoop we had to
You know what? That's the hypothetical I give for probate every time. You know, your long lost grandmother is the beneficiary of your life insurance. She's predeceased you at your death, no living beneficiary. It's going to go through probate. And the will says if you have a trust, it's a pour over will and it goes through the trust and magic happens, but it will take probate to get there. And normally if we get calls on things that get missed, it's life insurance and vehicles.
Yeah, absolutely.
So I tell clients every now and then it's a good idea, every, I don't know, 5, 6, 7, however many years, especially if your financial institutions change ownership or change names, just double check to make sure everything is set up the way that you want it. We had one client, her husband rolled his IRA, and when it rolled into a new account, you remember this one, Rachel, you handled it. They didn't add the beneficiaries, so it went through probate.
Yeah. And Amber, I don't know if you can see, but there's a chat on the side with some questions too. So I'll get to that in a minute. But before I do, what people also, there's a misunderstanding about wills. So they think if they have, if your grandma dies and you find her will, well, she's got a will that I don't need to do anything with it. People don't understand that. In each state, you have a certain amount of time to file that will with the court. So in Kansas, you have 6 months from the date of death, and in Missouri, you have a year. So if you don't do anything with that will, and in Kansas, let's say a life insurance policy, and that, like what you brought up, would be found, 9 months later, and you didn't do anything with the will, that policy then would go through court as if there was no will. You have to preserve it with court. So whenever you have a loved one who dies, you have to make sure, just call an attorney, they'll know what to do with the will. Again, in Missouri, you have a year, Kansas, it's 6 months. And it's not opening up probate, but you have to send the original will to the court. It's a form you file. You fill out some information about the person who's passed. You prove that they've, with a death certificate, and you're presenting the original will to the court. So if anything does come up later, it is divided the way the will outlines it. Otherwise, it would go as if there wasn't a will. And for instance, in Missouri, if you die and you're married and you have kids in common, there's a percentage that goes to the wife and percentage that goes to the kids, and then you split some. And so the will might have said all to the wife, but if you don't have that will on file, then it goes as if there wasn't a will. So that's really important to understand. Some people think, I don't need the will, everything has a beneficiary designation, and that may be true, but it's always good to have one if things would pass differently with a will versus without a will. So on the side, it says that there's a lot of questions from people who assume that a power of attorney, like the agent, is in control of a living will or a trust. So, Amber, I don't know if you want to talk about that.
Yeah, there's different jobs. The way our power of attorney has to have, in order for a power of attorney to be able to amend a trust, the document has to give that person the ability. So there's certain things that have to be listed in a power of attorney to give that person the ability to make those decisions. Sometimes a power of attorney can amend the trust for the person, and sometimes not. And so it's a different job than being a trustee. Power of attorney ceases at death, so they do not automatically become the executor of your estate. When you die, the power of attorney dies.
Well, and I guess also some people get go to websites that ask them to pay for an EIN, that you don't pay for an EIN. Those you get free from it's irs.gov. So you don't ever have to pay to get that tax ID number.
If you're doing it on your own, if you're having an accountant or somebody do it, they're probably going to charge you a fee. But yeah. There was another question, Rachel, that popped up about when do you file a will?
Oh, so some states are different. Sometimes you can deposit a will for holding at the courthouse, but really it's after death when you would file the will. So, and again, and I'm really being general with the terminology because it's different in Kansas. You're actually preserving it. And so I'm just being general in it. Call an attorney and ask, what do I need to do with this will? And depending on where you live, they'll let you know. But here in Kansas and Missouri, the general practice is to get it to the court after death.
And then I had another question that had popped up over here. If you are a co-owner on all bank accounts, is a will still necessary?
Go, Rachel.
Co-owner always makes me a little nervous. Something I think people need to understand, because we meet with clients sometimes and then they run off and say, I'm just going to put my son or daughter on the account with me now. And I just think that people need to be very cautious of that, because then creditors are able to get to that account as, your son or daughter, if they're on it and something happens, creditors can get your money. So you want to be cautious with that. But if there is a co-owner on an account, then it just goes to that person at death, whoever the co-owner is. Again, it's not we do want to be very careful. Co-owner, it's not an estate plan. An estate plan would be your will and a trust. And there are, things you can do to try to minimize, having to do that. But if you do have an account that has a co-owner, that wouldn't go through court. I wouldn't say that necessarily means you don't have to have a will, because you never know what's going to happen. What if that co-owner predeceases you and you don't have a beneficiary on the account? There's just so many different hypotheticals that could happen. So you can do a lot of planning so that I kind of explain it that a will is kind of like an insurance policy, right? It's there in case you need it. If your family dynamics are good and you know who you want to get, what property, then you can take care of those with co-ownership, transfer on death, pay on death, things like that. But the will would, be there to catch anything that was missed. And also sometimes wills are good. I think Amber started to mention, if family dynamics aren't the best, sometimes people say, you know what, I want the court. There are actually very good things to probate. I know probate gets bad. People are like, oh, I don't want probate, but it can also be good if you want the court to have oversight on how things are divided. So it's not always a bad thing. It may fit your situation so that there is a judge involved watching what happens and making sure things are done the way you want, as outlined in your will. So,
and that's also
more.
Yeah, because with the will, to have oversight, if it's a smaller estate, it makes a lot of sense. For people who have larger estates, a trust you can list a third party, like a bank. We don't provide trustee services, but there are institutions that will be trustees of trusts, and they can be that third party that oversees it. But like Rachel was saying about the will, I had a client, there was not a lot of money. There was a house, I believe it still had a mortgage, and he was leaving all of his assets to charity. So it made sense to do a will. He spent a few $100s as opposed to a few $1,000s, and then at his passing, because charities don't want to inherit real estate, so the executor stepped in, paid bills, did this, that, and the other, sold the house, and whatever was left, then the charity got the check. So yeah, so to back Rachel up, probate can actually be a very good thing and appropriate. So it isn't always bad.
Then I have another question. If an elder is in nursing care, can the life insurance policy be cashed by the DPOA to help pay the long-term care? And when can you do that?
It depends on the language and the power of attorney. So if a life insurance policy has cash value and the document gives you the authority, yes, you can cash that policy in and pay for long-term care.
And that was all I'm seeing. Is there anyone else that has a question, or are you guys seeing any others pop up?
I don't.
Okay.
But I'm not the tech savvy one.
I know. I had to kind of play with it. I told you I'm
a fossil.
I can't figure out my MacBook. It's all over the place. My 20-year-old could sit down and have it all figured out right away.
Yeah.
All figured out. We were talking about beneficiaries and something that I came across, especially being in memory care, sometimes that changes the dynamics because, again, you're talking about that capacity and being able to make those decisions. A couple of years back, we actually had a resident in memory care who the family was unaware was actually listed as the trustee to, I guess, a will or something for her brother. And he passed away, and it was quite a battle to prove that she was not capable of being, that person to that will, the executor to that will, because she obviously couldn't handle her own affairs. And it was kind of a long, drawn out process. I mean, they had to have people document her level of dementia. There was actually at one point someone, I don't know if it was an attorney or someone who came and actually visited with her at the memory care just to be able to say, she didn't have that ability. So talking about beneficiaries, even ask your family, make sure that especially if you have a loved one who it does have dementia and is going into, not being able to make their own decisions, make sure they're not on anyone else's either, because that can be a little tricky if you're not aware.
Okay. Looks like we got a question about protecting assets if your loved one needs to go into long-term care. That's when calling us for your free consultation is a great idea. Because there's a lot of factors that play into that, income, assets, Medicare and Medicaid are different. I explain Medicare is your health insurance. Medicaid is like long-term care insurance. So at our office, people can call in for an initial consult and we gather some background to figure out, hey, can we help you? And if we do, we can set up that free consultation, or sometimes it's like, this isn't what we do and here's who you need to call. So we never charge to talk on the phone initially. So happy to kind of help filter through. I think his name is Mike. Help filter through some of those questions for you. You can give us a call. And I guess we should do the little call 1-800.
Hold up the little sign with your.
The number is, it's 913-338-5713. 913-338-5713. I feel like a commercial.
Yeah. Well, and for any of my families, I have your contact information as well, so they can always reach out to me. We did have another question pop up. If my memory and mental capacity is gone, I would prefer to be, I'm not sure, I could be in my wished need to be stated in my living will, or can a supporter be okay to implement? I think is what the
maybe call our office or email us tomorrow.
Yeah.
And then we can follow up with that specific question.
Yeah, I don't know if it's my eyes or I just am not reading it correctly. Yeah, definitely. And we appreciate your time. I know I could sit here and ask you 100 questions probably.
Well, call us tomorrow.
Just from my own experience. And again, dealing with families and that whole process of moving people into a community, those questions always come up. And I know everyone kind of has a differing opinion on the right answer. And I always try to default to, ask an attorney because.
And that's why it can't hurt to call, because a lot of times when people call, they're in good shape.
Yeah.
They don't realize it, and they've been worried and stressed, and now I have been wanting to do it. And then when they get off the phone, like, oh, I feel better.
Yeah.
So.
And I think, always plan ahead. We've had many people move in who knew long in advance that they wanted to be able to have their wishes known, and they planned ahead, and it makes the whole process so much smoother, even down to their dying wishes. It really does make it so much smoother if your family and your loved ones know what that plan is and what you want to happen.
And then also in thinking about your kids too, avoiding any conflict between your kids.
Yeah, I always tell people, if you don't love your kids, then don't do anything.
Yes. I'm sure everybody has seen some pretty.
We had a couple come in like that.
Family.
Like, why did you come in? Like, oh, well, and it was, anyway, they were quite the couple. They called lost, needing directions, and it was quite interesting. They were in their 90s yelling at each other in the car.
Oh my goodness. Oh my goodness.
Anyway.
Well, I definitely appreciate your time. I'm not gonna, I think we're sitting at about 6:45. So I know that you've answered so many questions for me. I took some notes, and hopefully as I think of more questions, I will definitely reach out.
Yeah, and we kind of gave some broad brushstrokes, you know, talking about trust and wills and life insurance and things like that. If you've got a specific question before you pull a trigger, it cannot hurt to call us and just verify that, yes, as the life insurance policy, should I cash it in? Is there a different option? Sometimes they're exempt. You know, there can be lots of options. So just reach out to us, some elder law attorney that you know, whatever. But yeah, can't hurt to run it by somebody.
Yeah, definitely appreciate it. And we will have you all back, especially when we can do something live. I think that's always a good opportunity too for people to, you know, ask that question in person. Sometimes that's just, you find that a lot of them have the same question and just nobody asked. So
Plus then you get wine and snacks.
yeah, yes.
Yeah, we're out of wine at the office. So.
Yeah. We'll send you an invite to Angie's event she's having next week, and you'll be very pleased.
Actually, I moved it a week later, Annette.
Oh, good. Okay. Well, we'll get it. Make sure you all get an invitation to that. So I guess we'll close that out, and I appreciate your help, and the information was great. It answered several of my questions. So definitely appreciate your time, and we will talk to you all soon.
Okay.
Good.
All right. Thank you.
Thank you. Nice to meet you guys.
Bye.